All right, ladies and gentlemen, it's time for the closing argument of the state. Ms. Francis.
Oh, what a tangled web we weave when first we practice to deceive. That could have been written for this defendant, because that's exactly what this case is about. It's exactly what she did. In order to believe what the defense just stated to you, you have to believe everything that the defendant told you from this witness stand. And if you do that, you have to disbelieve. In other words, not believe any other witness that got on this witness stand. Any other civilian, any other officer, any FBI agent, even Liddy Howard. You have to disbelieve all of them in order to believe what the defense just told you and what the defendant said. Reginald Day, otherwise known as Reggie to all his friends and all his family, 46-year-old man who you've heard nothing about in this trial but good things. How he was nice to people, he would help people, he would do everything he could. He was a good person. And he was deceived by this defendant, and it resulted in his death. Now the judge is going to instruct you on the law. I want to talk about just a little bit of it here. He's going to instruct you on first-degree murder, second-degree murder, and voluntary manslaughter. In order to do first or second-degree murder, you do have to have malice. It's intentionally kill the victim. It can be with a deadly weapon. Malice can be inferred. It can be ill will, hatred, or intentionally inflict a wound upon the deceased with a deadly weapon that approximately caused that person's death. That's what happened here, ladies and gentlemen. A knife is a deadly weapon. A knife was used to inflict that injury on Reggie. Now, it might be different if you push somebody and they fell down the stairs and they later died. But when you use a weapon that is dangerous and deadly by its very nature, what do you think is going to happen to them? If you either stab them or shoot them, take a shovel, slam them over the head with it, you got to look at the type of weapon that was used. Definitely malice in this case, by the defendant. What else shows malice? That knife right there. We're not talking about a little bitty pocket knife. We're not talking about the little Swiss knives. What we're talking about is a knife with a 6-inch blade. That's what Dr. Nichols told you. But then you look where that knife is too. Remember that. Next, the state has to prove to you that the defendant had the intent to kill in order to get first-degree murder. Now, it's a mental attitude. How many times is a person going to come up to you with a knife and say, I'm going to kill you? When? Never. Never are you going to see that. So you have to remember all the evidence that you heard from right here. You have to remember all the evidence that you looked at. And you have to take those circumstances and you can infer that this defendant right here had the intent to kill Reginald Day because she did. Look at the number of knives. See that block? That block is completely empty. Every knife that was housed in that block is gone. And it is throughout that apartment. That shows intent. Look at all the knives in the bedroom. Now, the defense wants you to think that Reggie Day did all of this because he what? Throws knives like martial arts, throws them. Remember those knives on that floor? How many of them were broken? Just about every one of them was broken from the handle, and one was broken in pieces. When you're looking at intent, you also look at the victim. Did the victim have any defensive wounds? Any bruises, any cuts, any scratches? What about this case? You heard from Dr. Nichols. His whole left arm was bruised up, and in his opinion, that was defensive wounds. You heard from FSU Biddex Austin, who took pictures. Not only did he have bruises, but he also had scratches all over this arm, the left arm. He had scratches on his back, defensive wounds. You heard from Mary Ann Bond. He had a cut on his finger, defensive wound. What does that mean? That means what the evidence shows is the truth. The defendant went to that kitchen, got knives at different times, but at least once she went to that kitchen and got that murder weapon. She came back to it, came toward Reggie, and attempted to stab him just like she told James Williams 3 times. One of those got his knuckle. And he's using his arm to defend her. But he didn't make it the last time. And she slammed that knife into him to the hilt. All 6 inches of that blade went into his body. Now the state's evidence has shown to you that yes, they're in an argument. That argument starts, and yes, he's not wanting her to leave because what did he tell you? She had been drinking, she felt really good, and she had told him what she does then. So when she wanted to go see a client, we're not talking about a date, like normal people think of a date. She was going to see a client. He told her, no, that's not a good idea because why? Reggie's looking out for her. Remember, he's the one that takes care of people, gives people money that needs it, helps anybody that needs asking. And he knows if she goes out that night and she's intoxicated, something bad might happen. He never said he held her down. All he did was grab her. Like you grab somebody by the shoulders. You don't need to go anywhere. He didn't close the front door. He never said that. He never said he blocked her anyway at all. And what did she do after they got in that argument? She smashed all his belongings, and she goes in the kitchen, gets the knife, comes back down, has to fight with him to get to him, and stabs him. That is intent to kill. Now, proximate cause. You see the big letter A. That's because it doesn't have to be the sole proximate cause. But if you stab someone with a 6-inch blade on their left side, anybody with common sense knows your heart's right here on the left side, as well as most of your other important organs. If you stab somebody 6 inches to the hilt, what do you think is going to happen? The chances are that is a very dangerous, serious wound that's going to kill. Reggie goes into the hospital. You heard from Dr. Nichols. He had complications as a result of that stab wound. He told you that the lung was cut, the colon was cut, the spleen was cut. He never said anything about a liver. And on the stand, he admitted that when he looked back at the notes, that the stomach was not actually cut, but it had sutures in it. So he told you everything that was scientifically correct. But the important thing is he told you Reggie got an infection. Anybody, again, using your common sense, you go in for any type of surgery, it can even be a minor surgery. There's always risk of infection. The colon is cut. What happens when your colon is cut? All that toxin leaks out into your body. They did surgery, they closed that colon the best they could. There's always risk of infection, and that's what happened. But you can't stab somebody with a 6-inch blade and not expect them to not die. It was a complication from the stab wound. If Reggie had never been stabbed, he'd never be in the hospital, and he would not be dead. It only has to be a proximate cause. premeditation, have to form the intent to kill. You notice I snap fingers because that can be done just like this. You can be looking at somebody 1 minute, have a gun in your hand like that, pow, and that person's dead. Same way with a knife, and that's what she did in this case. The defendant took that knife, she had to go get it, had to come back with it, and had to fight with him and stab him. She had the intent to kill. You also have to show deliberation, a cool state of mind. But what the defense didn't tell you, it's not total absence of emotion or passion. So you can be angry, you can be mad, but you still have enough cool state of mind to make that intent to kill and to carry it out. The defendant in this case did that. When you're trying to decide between premeditation and deliberation, again, it's often hard from the witness stand. You have to listen to all the evidence and listen to the circumstances. What you look at is the conduct of the defendant before, during, after, and whether there were any threats or excessive force. In this case, before, she's going to go out with another man. She gets in an argument with Reggie over that. He does place his hands on her, but he only grabs her. She then goes and starts tearing up everything he has and starts getting physical with him. She's the aggressor, she's the one getting physical, and she stabs him. And what did she do? You heard from Kia Haynes, the next door neighbor. She knows Reggie, knows he's a nice guy, she knows who Crystal is, but they don't talk a lot. She saw Reggie run out, saw the defendant at the door who said everything's fine and slammed the door. The last person in that apartment was the defendant. She then leaves after she's through tearing up the rest of the apartment. She leaves, goes to Liddy Howard. You heard the 911 calls. She called an hour, over an hour after this happened, and hung up. Then even after that, her son called, so it's even been further time. So is that somebody that's not premeditated and deliberated? No. She has premeditated and deliberated the murder of Reggie Day. It's another thing for you to look at. Where is the blood in the house? Now, you've heard the officers say that they saw some blood from the living room going down the hall. The forensics officer collected swabs from right here and right here. They also saw something red on the bed right here and did a swab of that. It was sent to the lab. What did the lab find? What's on the couch and what's in the hallway was Reggie's blood. What's on the mattress, which the agent Posto told you gave an indication of blood, but it was not confirmed. They don't do confirmatory. But when DNA told you there was no DNA there, that tells you it's not blood. Nail polish, maybe, not blood. This is the blood in the hallway, right there. This is a close-up of that blood. It's in the hallway right here. That's Reggie's. Number 2 was Reggie's. Number 10 is Reggie's. Do you see the defendant's blood anywhere? No. Outside, what do you see? Reggie's blood. What else do you see here? The murder weapon. There's Reggie's blood. There's the murder weapon that has blood on it. There's a closer up and look. See that little piece right there? That's a metal tip off of a knife. That one has a metal tip. That one does too. And there's a blade stuck in the couch. That's important. There it is again, close up of the one that was stabbed in the couch and broken off. There's the metal tip that I was just discussing. Same metal tip like on that knife, but it doesn't go to a single knife on that couch. What does it go to? This is the kitchen. This is the knife right there, number 7. It's missing the blade and it's missing the tip. Again, that shows intent, premeditation, deliberation. Look at all those knives. Is that a knife someone took to the bedroom and threw? No. That's a knife that somebody deliberately destroyed. This again shows all the knives. What's important right here is some sort of date book. Right there appears to be a phone, and right there appears to be a piece of paper out of that date book. Is it her client's list? Is that the phone she was using in the bathroom? To not try to get away from Reggie, but to go on a date, just as Reggie was telling you through Agent Bond. Now, the defendant wants you to believe self-defense. And in order to believe that, you have to think it was necessary to kill the victim to save her from death or serious bodily harm. And you have to think that the circumstances were such that a reasonable person of ordinary firmness would have believed the same thing. And you also have to find that she was not the aggressor. Well, let's look at what the evidence shows. They spent a tremendous amount of time on this bathroom door. But if you remember, even the defendant admitted that it was the bathroom door that Reggie kicked in. They repeatedly tell you that Reggie said he kicked in the bathroom door. His response was to Agent Bond's question. He didn't say hall bathroom. He said, yeah, I think I kicked in the bathroom door. Where were they when this happened? Bedroom. Closer view. You see this lock down here. You see this and this. Again, would he, kicking that door right there, have knocked it off the hinges and pulled it out? No. And I will explain to you why in a minute. Then you have a closer up view. And if you notice that hair right there, it's on top of the lock. And I'll tell you why that's important in a minute too. This is the bedroom door. Look at that. That's more consistent with somebody's foot kicking. The other one looked more like somebody's fist hitting. You got to look at the way, the shape, and how it's knocked in. What Reggie kicked in was this bedroom door to the bathroom. Again, if you look very closely, it looks more like someone kicking versus punching. And again, look at where the hair is, number 9. It's right there at the kitchen sink. Again, you see this hair. It looks cut. And if you remember, Agent Remy said it was cut hair. Now, I know the defense says, well, that's not important. We think it's her real hair. Now we're trying to say it's a weave. It's not what the state's saying. What the state is saying, that's Caucasian hair. That's white hair. That's hair that's been cut, not pulled out. If you pull out somebody's hair, you're either going to pull it and pull some of the root out. The only other way would be if you took your hair and did that, it's not going to break. And what did Reggie say? I grabbed it, it just fell out and I let go. This hair is not the hair that Reggie pulled out. Well, let's talk about the length of that hair. 6.5 centimeters, the hair in the bathroom. That's right there. Now, is that going to be used for a weave? Weaves are in packs. And they're cut hair. And they're going to be longer. And they're going to have an end on it if it's sewn in or glued in. None of these had ends. What's even more strange is they did have roots. Now, a weave's not going to have roots, so whose hair do we have? That's a question. And if it's the defendant's weave, she obviously cut it. And why did you not see the hair? Evidently, the defendant didn't hear what Remy said. Remy said she placed every piece of hair on a slide. So it's all in a biohazard box and slides. That's why you didn't see the hair. Then we're back here to the bed. What's strange about this bed? Really, nothing. You got a box spring, you got a mattress on top of it. The defendant wants you to believe that she was pulled off the bed by her ankles and the mattress came with her. And that she hid under that mattress when Reggie went and got the knives and came back and threw them at her. And she couldn't leave because he was getting those knives and throwing them martial arts style. Any holes in that mattress? No. Is that mattress off the floor? No. Would throwing a knife at a mattress break the blades? No. It did not happen the way the defendant said it happened. Not at all. Look at this closer view. The only hair other than in the bathroom is right there. And again, it's as if you took a brush and pulled it out and left your hair there. Again, whose hair it is, we don't know. If it's a weave that she put in her hair, it couldn't have been bought in a package because it had Caucasian white roots on it. And again, you didn't see any stab holes in that mattress. Then we have Crystal herself. Does she have any wounds? If she's trying to get him off of her, and he's on top of her choking her, where's the scratches on her hands? There are none. The only scratch is right there, left hand. It came from when she pulled her cuffs out. She didn't get any scratch while she was at Reggie's house. And if you look at her shirt, it's not torn. The state held that shirt up. It was one of those elastic ones that you can pull down. The only thing torn is this. But was it torn or has it come undone? The lace itself is not ripped. And again, you saw her hair at the back of the head. There's not a single hole here, scalp, or anything. But what's the most impressive is this right here. She's choked so much she sees black spots. There's not a scratch, not a bruise, not a red mark. Even more, you can tell it's not swollen because you can see her throat and you can see her muscles right there. It looks just like mine does today. Nobody ever touched that throat that night. Then you see her face, you see her cracked lips. Back in February of 2010, she also had cracked lips and tried to say she was beaten in the mouth then. She was not. She had cracked lips and she had a blister that was oozing pus. And again, scratch that has already partially healed, which looks like you take your fingernail and you mistakenly scratch in your eye and you scratch your skin. And again, no particular or anything to show strangling. What the defendant says happened could not and did not happen. But the state can tell you what did happen based on all the pictures you saw, based on what every agent with the SBI said, and based on what Reginald Day told you through Mary Ann Bond. Keep in mind, Reginald Day is in pain. He's heavily medicated, but he tried his best to tell everything he could remember happened. And that includes grabbing the defendant. Not holding her down, but grabbing her. Grabbing her hair to drag her. He never said he dragged her. He said when he grabbed it, some came out and he let go. Here's how we know what happened. Mr. Day was stabbed right here. This is where the most blood is. In this whole bedroom, there's not a speck of blood on that floor. If Mr. Day is on top of the defendant, choking her, and she stabs him with her right hand, there's going to be blood on that floor. Because she pulls that knife out. When you pull that knife out, blood's going to come off that knife if nothing else. It's pouring down his side too, but if you believe their story that he's not bleeding that bad, even though every witness has said he did, then when you pull that knife out, blood is going to get on that floor. And she said she didn't remember what she did with the knife, so we know she had the knife. It could not have happened in this room. He kicked this door in, grabbed her hair, it fell out. He's leaving. She goes through here, comes out, gets the knife, meets him in that hallway. And that's where he struggles with her to try to take it away, and that's where she stabs him. That's what the evidence shows. There's no other way it could have happened. And then what did Reggie do? He ran out. He ran down the stairs and over to the next building where his cousin was. And Kia Haynes told you that defendant was still in that home, that she slammed the door and said, everything's fine. Well, okay, this is where you go back and you look at Milton Walker in 2010. Motive, intent, and plan. That's why you saw that evidence and heard that evidence. Because the same thing happened. She got in an argument with Mr. Walker. And you heard from Mr. Walker. He couldn't have lied if he wanted to. He's a simple, honest man that didn't want to tell you what happened, but he did. And he told you the truth. Same thing. Gets in an argument with Crystal. The difference is here, instead of going on a date, she's kicking him out because she's having another man move in. I mean, she told you she loves men. And in 2010, same thing happened. She started it. And when he put his hands on her neck to hold her down until she calmed down, but she didn't calm down. He let go. What happened? She picks up a chair, attacks him. She picks up a ladder and attacks him and goes to the kitchen, and you hear the silverware rattle. Did he stick around? No. He ran. Officers come. Officers are there. What does she do? She grabs a knife and runs after him and says she's going to stab him. And in between this, after he runs, but before the cops get there, what does she do? She sets the stage. The chair's put up, the ladder's put up, but his property's destroyed. Tires are slashed, windshield smashed. That all happened after she tried to attack him. Motive. Same motive. Doing the exact same thing here. Intent. Her intent was the same thing. The difference here is Reggie didn't run. Reggie didn't run. Same plan. She did the exact same thing in 2010 that she did April 3rd, 2011. She had a plan. She knew what she was doing. She knew what would happen. And that's what she did. She killed Reggie Day. She killed a person that everybody you heard from said was loving, peaceful, friendly. And they want you to believe this circle of violence, domestic violence. Remember what the expert said. Not only did she think Crystal was a victim, but she also thought this defendant was an abuser. And abusers go in a cycle. She talked about 2 relationships, Milton Walker and one other relationship. Well, you heard about her relationship with Milton Walker. Milton was the victim. The defendant was the abuser. Same thing with Reggie. A peace-loving man. He painted and he liked his beer. There's no doubt about it. He probably drank his beer every day. Didn't bother a soul. Give you the shirt off his back, give you money, let you move in, helped his cousins. And he had a girlfriend for 11 years. What was their fun thing to do? Play spades on a Friday night and drink his beer. Not a thing to show that he has ever been an abuser or was an abuser on this night. The defendant is the abuser. The defendant is guilty of first-degree murder. She had malice, she had motive, she premeditated, she deliberated, she had the intent to kill. And lastly, they keep talking to you about the video. Why did we show the video? She's tired. I mean, it's 4:30. It's been 3 hours. Tell you why. She's sitting in a chair. She's got her handcuffs behind her back. While she's sitting there, there's an officer straight across from her. Keeps telling her, quit trying to wiggle out of your cuffs. But what does she do? She wiggles that left hand out, and you see her do it, but she puts it back. It's not until the EMS gets there that you see she has pulled her hand out of the handcuff. And then after that, she smiles and starts laughing and flirting with the officer that's sitting there. And she just stabbed a man that's died. She just committed murder. And she wants you to believe she was beat up 5 or 10 times and was hurting all over and couldn't move. Hands behind your back, ladies and gentlemen. The whole video, where is she? Down here. Now this is not a comfortable position. If you're in pain, are you going to be able to do this? Half the time she was halfway up, she was like this, and back down. You can't do it. If you've been beat up so bad that the only way to get away from the person beating you up was to stab him because otherwise he was going to kill you, would you be doing that? Would you be flirting? Would you be doing all those positions? Would you be sleeping? No. That's the reason you were shown the video, ladies and gentlemen. The defendant is a killer. She committed first-degree murder, and she is a killer. And you got to look at all of her conduct in a whole. She fled from the scene. She didn't call 911 until somebody made her. Then she wouldn't even tell them what happened. Then she made her son do it and wants you to believe that's not her behind it. Then she comes in, supposed to be so tore up, so beat up, and so much a victim, and contorts her bottom almost into a sandwich and sleeps until she pulls the chair up and lays down and flirts. Ladies and gentlemen, that's a killer. That is a killer. It's not somebody that commits manslaughter. That's somebody that commits first-degree murder. Listen to the instructions. Use your common sense and your everyday reasoning. Follow the law. And if you do that, you're going to find that defendant guilty of first-degree murder. Reggie Day, 46 years old, he didn't deserve it. He didn't deserve to die for trying to help someone. His family, who's been here this whole week, didn't deserve it. They've waited for 2 years for justice. They've sat here quietly. They've had to endure. They've had to see things. They deserve justice. Reggie deserves justice. Find that defendant guilty. Thank you.
Thank you, Ms. Franks. All right, ladies and gentlemen, I'm going to ask the bailiff to hand out printed copies of the instructions on the law that I'll be giving you. These instructions, printed copies, will be yours to take back into the deliberation room. If you wish to make notes on them, you're free to do so. What I'd ask you to do is not read along, or read ahead of me in the instructions. Just read along with me if you care to, or sit back and listen. You'll be able to take those instructions in with you. Bailiff, if you'll hand those to the jurors, please. Members of the jury, all of the evidence has been presented, and it's now your duty to decide from this evidence what the facts are. You must then apply the law that I'm about to give to you to those facts, and it is absolutely necessary that you understand and apply the law as I give it to you, not as you think it is or might like it to be. This is important because justice requires that everyone tried for the same crime be treated the same way and have the same law applied. The defendant has entered a plea of not guilty. The fact that the defendant has been charged is no evidence of guilt. Under our system of justice, when the defendant pleads not guilty, the defendant is not required to prove the defendant's innocence. The defendant is presumed to be innocent. And the state must prove to you that the defendant is guilty beyond a reasonable doubt. A reasonable doubt is a doubt based on reason and common sense. arising out of some or all of the evidence that has been presented, or the lack or insufficiency of the evidence, as the case may be. Proof beyond a reasonable doubt is proof that fully satisfies or entirely convinces you of the defendant's guilt. You are the sole judges of the believability of witnesses. You must decide for yourselves whether to believe the testimony of any witness. You may believe all, any part, or none of a witness's testimony. In deciding whether to believe a witness, you should use the same tests of truthfulness that you use in your everyday lives. Among other things, these tests may include the opportunity of the witness to see, hear, know, or remember the facts or occurrences about which the witness has testified, the manner and appearance of the witness, any interest, bias, prejudice, or partiality that the witness may have, the apparent understanding and fairness of the witness, whether the testimony is reasonable, and whether the testimony is consistent with other believable evidence in this case. You are also the sole judges of the weight to be given to the evidence. If you decide that certain evidence is believable, you must then determine the importance of that evidence in light of all other believable evidence in this case. In this case, you've heard testimony or evidence from witnesses who have testified as expert witnesses. An expert witness is permitted to testify in the form of an opinion in a field where the witness purports to have a specialized skill or knowledge. As I've instructed you, you are the sole judges of the credibility of each witness and the weight to be given to the testimony of each witness. In making this determination as to the testimony of an expert witness, you should consider, in addition to the other tests of credibility and weight, the witness's training, qualifications, and experience, or lack thereof, the reasons, if any, given for the opinion, whether the opinion is supported by facts that you find from the evidence, whether the opinion is reasonable, and whether it is consistent with other believable evidence in this case. You should consider the opinion of an expert witness, but you are not bound by it. In other words, you're not required to accept an expert witness's opinion to the exclusion of the facts and circumstances disclosed by other testimony. Photographs and diagrams were introduced into evidence in this case for the purposes of illustrating and explaining the testimony of witnesses. These photographs and diagrams may not be considered by you for any other purpose. There are two types of evidence from which you may find the truth as to the facts of a case. There's direct evidence and circumstantial evidence. Direct evidence is the testimony of one who asserts actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a chain or a group of facts and circumstances indicating the guilt or innocence of the defendant. The law makes no distinction between the weight to be given to either direct or circumstantial evidence, nor is a greater degree of certainty required of circumstantial evidence than of direct evidence. You should weigh all the evidence in this case. After weighing all the evidence, if you're not convinced of the guilt of the defendant beyond a reasonable doubt, you must find the defendant not guilty. Evidence has been received tending to show that at an earlier time a witness made a statement which may conflict with or be consistent with the testimony of the witness at this trial. You must not consider the earlier statement as evidence of the truth of what was said at the earlier time because it was not made under oath at this trial. But if you believe the earlier statement was made and that it conflicts with or is consistent with the testimony of the witness at this trial, you may consider this, together with all other facts and circumstances bearing on the witness's truthfulness, in deciding whether you will believe or disbelieve a witness's testimony. Evidence has been received concerning criminal convictions of a witness. You may consider this evidence for one purpose only. If, considering the nature of the crimes, you believe that this bears on the witness's truthfulness, then you may consider it, together with all other facts and circumstances bearing on the witness's truthfulness, in deciding whether you will believe or disbelieve the witness's testimony at this trial. You may not consider this evidence for any other purpose. Evidence has been received concerning prior criminal convictions of the defendant. You may consider this evidence for one purpose only. If, considering the nature of the crimes, you believe that this bears on the defendant's truthfulness, then you may consider it, and all other facts and circumstances bearing on the defendant's truthfulness, in deciding whether you will believe the defendant's testimony at this trial. A prior conviction is not evidence of the defendant's guilt in this case. You may not convict the defendant on the present charges because of something the defendant may have done in the past. Evidence has been received tending to show that on a prior date, namely in February 2010, the defendant was engaged in a confrontation with another person, namely Milton Walker. This evidence was received solely for the purpose of showing that the defendant had a motive for the commission of the crime charged in this case, the defendant had the intent, which is a necessary element of the crime charged in this case, and that there existed in the mind of the defendant a plan or design involving the crime charged in this case. If you believe this evidence, you may consider it, but only for the limited purpose for which it was received. You may not consider it for any other purpose. The state contends, and the defendant denies, that the defendant fled. Evidence of flight may be considered by you, together with all other facts and circumstances in this case, in determining whether the combined circumstances amount to an admission or show a consciousness of guilt. However, proof of this circumstance is not sufficient in itself to establish the defendant's guilt. Further, this circumstance has no bearing on the question of whether the defendant acted with premeditation or deliberation. Therefore, it must not be considered by you as evidence of premeditation or deliberation. The defendant has been charged with first-degree murder. Under the law and the evidence in this case, it is your duty to return one of the following verdicts: guilty of first-degree murder, or guilty of second-degree murder, or guilty of voluntary manslaughter, or not guilty. First-degree murder is the unlawful killing of a human being with malice and with premeditation and deliberation. Second-degree murder is the unlawful killing of a human being with malice, but without premeditation and deliberation. Voluntary manslaughter is the unlawful killing of a human being without malice and without premeditation or deliberation. And the defendant would be excused of first-degree murder and second-degree murder on the ground of self-defense if, first, the defendant believed it was necessary to kill the victim in order to save the defendant from death or great bodily harm, and second, the circumstances as they appeared to the defendant at the time were sufficient to create such a belief in the mind of a person of ordinary firmness. In determining the reasonableness of the defendant's belief, you should consider the circumstances as you find them to have existed from the evidence, including the size, age, strength of the defendant compared to the victim, the fierceness of the assault, if any, upon the defendant, whether the victim had a weapon in the victim's possession, and the reputation, if any, of the victim for danger and violence. The defendant would not be guilty of any murder or manslaughter if the defendant acted in self-defense and the defendant was not the aggressor in provoking the fight and did not use excessive force under the circumstances. One enters a fight voluntarily if one uses towards one's opponent abusive language, which, considering all the circumstances, is calculated and intended to provoke a fight. If the defendant voluntarily and without provocation entered the fight, the defendant would be considered the aggressor, unless the defendant thereafter attempted to abandon the fight and gave notice to the deceased that the defendant was doing so. In other words, a person who uses defensive force is justified if the person withdraws in good faith from physical contact with the person who was provoked and indicates clearly that she desires to withdraw and terminate the use of force, but the person who is provoked continues or resumes to use force. A person is also justified in using defensive force when the force used by the person who was provoked is so serious that the person using defensive force reasonably believes that she was in imminent danger of death or serious bodily harm. The person using defensive force had no reasonable means of retreat, and the use of force likely to cause death or serious bodily harm was the only way to escape the danger. The defendant is not entitled to the benefit of self-defense if the defendant was the aggressor with the intent to kill or inflict serious bodily harm upon the deceased. A defendant does not have the right to use excessive force. A defendant uses excessive force if the defendant uses more force than reasonably appeared to the defendant to be necessary at the time of the killing. It is for you, the jury, to determine the reasonableness of the force used by the defendant under all the circumstances as they appeared to the defendant at the time. So therefore, in order for you to find the defendant guilty of first-degree murder or second-degree murder, the state must prove, beyond a reasonable doubt, among other things, that the defendant did not act in self-defense, or failing in this, that the defendant was the aggressor with the intent to kill or inflict serious bodily harm upon the deceased. If the state fails to prove the defendant did not act in self-defense, or was the aggressor with the intent to kill or inflict serious bodily harm, you may not convict the defendant of either first-degree or second-degree murder. However, you may convict the defendant of voluntary manslaughter if the state proves the defendant was the aggressor without murderous intent in provoking the fight in which the defendant was killed, or that the defendant used excessive force. So for you to find the defendant guilty of first-degree murder, the state must prove 6 things beyond a reasonable doubt. First, that the defendant intentionally and with malice killed the victim with with a deadly weapon. Malice means not only hatred, ill will, or spite as it is ordinarily understood, but it also means the condition of mind which prompts a person to intentionally take the life of another, or to intentionally inflict serious bodily harm that proximately results in another person's death without just cause, excuse, or justification. If the state proves beyond a reasonable doubt or is admitted that the defendant intentionally killed the victim with a deadly weapon or intentionally inflicted a wound upon the deceased with a deadly weapon that proximately caused the victim's death, you may infer first that the killing was unlawful, and second, that it was done with malice, that you are not compelled to do so. You may consider this along with all facts and circumstances in determining whether the killing was unlawful and whether it was done with malice. A knife is a deadly weapon. Second, the state must prove that the defendant's act was a proximate cause of the victim's death. A proximate cause is a real cause, a cause without which the victim's death would not have occurred. The act of the accused need not be the immediate cause of the death. A defendant is legally accountable if the direct cause of death is a natural result of the criminal act. Neither medically negligent treatment nor neglect of an injury will excuse a wrongdoer unless the treatment or neglect was the sole cause of death. In other words, the act complained of does not have to be the sole proximate cause of death, nor the last act in a sequence of time. It is enough if the defendant's unlawful act join and concur with other causes in producing the result. Third, that the defendant intended to kill the victim. Intent is a mental attitude seldom provable by direct evidence. It must ordinarily be proved by circumstances from which it may be inferred. An intent to kill may be inferred from the nature of the assault, the manner in which the assault was made, the conduct of the parties, and any other relevant circumstances. Fourth, that the defendant acted with premeditation. That is, the defendant formed the intent to kill over some period of time, however short, before the defendant acted. Fifth, that the defendant acted with deliberation, which means the defendant acted while the defendant was in a cool state of mind. This does not mean there had to be a total absence of passion or emotion. If the intent to kill was formed for a fixed purpose, if the intent to kill was formed with a fixed purpose, not under the influence of some suddenly aroused violent passion, it is immaterial that the defendant was in a state of passion or excited when the intent was carried into effect. Neither premeditation nor deliberation is usually susceptible to direct proof. They may be proved by circumstances from which they may be inferred, such as the lack of provocation by the victim, the conduct of the defendant before, during, and after the killing, the manner in which or means by which the killing was done, or ill will between the parties. And sixth, the defendant did not act in self-defense, or the defendant was the aggressor in provoking the fight with the intent to kill or inflict serious bodily harm upon the deceased. Second-degree murder differs from first-degree murder in that the state does not have to prove specific intent to kill, premeditation, or deliberation. For you to find the defendant guilty of second-degree murder, the state must prove beyond a reasonable doubt that the defendant unlawfully, intentionally, and with malice wounded the victim with a deadly weapon, proximately causing the victim's death. The state must also prove that the defendant did not act in self-defense, or if the defendant did act in self-defense, the state must prove the defendant was the aggressor in provoking the fight with the intent to kill or inflict serious bodily harm. I have previously defined the terms proximate cause and malice. Those definitions apply here as well. And again, a knife is a deadly weapon. Voluntary manslaughter is the unlawful killing of a human being without malice, premeditation, and deliberation. A killing is not committed with malice if the defendant acts in the heat of passion upon adequate provocation. The heat of passion does not mean mere anger. It means that at the time the defendant acted, the defendant's state of mind was so violent as to overcome reason, so much so that the defendant could not think to the extent necessary to form a deliberate purpose and control the defendant's actions. Adequate provocation means anything that has a natural tendency to produce such passion in a person of average mind and disposition. Also, the defendant's act must have taken place so soon after the provocation that the passion of a person of average mind and disposition would not have cooled. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act in the heat of passion upon adequate provocation, but rather that the defendant acted with malice. If the state fails to meet this burden, the defendant can be guilty of no more than voluntary manslaughter. For you to find the defendant guilty of voluntary manslaughter, the state must prove three things beyond a reasonable doubt. First, that the defendant killed the victim by an intentional and unlawful act. Second, that the defendant's act was the proximate cause of the victim's death. I previously defined the term proximate cause, and that definition applies here as well. And third, that the defendant did not act in self-defense, or, though acting in self-defense, was the aggressor, or, though acting in self-defense, used excessive force. Voluntary manslaughter is also committed if the defendant kills in self-defense but uses excessive force under the circumstances, or was the aggressor without murderous intent in provoking the fight in which the killing took place. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act in self-defense. However, if the state proves beyond a reasonable doubt that the defendant, though otherwise acting in self-defense, used excessive force or was the aggressor, though the defendant had no murderous intent when the defendant entered the fight, the defendant would be guilty of voluntary manslaughter. If you find from the evidence beyond a reasonable doubt that on or about the alleged date, the defendant, acting with malice and not in self-defense, wounded the victim with a deadly weapon, thereby approximately causing the victim's death, that the defendant intended to kill the victim, and that the defendant acted with premeditation and with deliberation, it would be your duty to return a verdict of guilty of first-degree murder. If you do not so find or have a reasonable doubt as to one or more of these things, you will not return a verdict of guilty of first-degree murder, but you will determine whether the defendant is guilty of second-degree murder. If you find from the evidence beyond a reasonable doubt that on or about the alleged date, the defendant intentionally and with malice, but not in self-defense, wounded the victim with a deadly weapon, thereby approximately causing the victim's death, it would be your duty to return a verdict of guilty of second-degree murder. If you do not so find or have a reasonable doubt as to one or more of these things, you will not return a verdict of guilty of second-degree murder, but will determine whether the defendant is guilty of voluntary manslaughter. If you find from the evidence beyond a reasonable doubt that on or about the alleged date, the defendant intentionally wounded the victim with a deadly weapon and thereby approximately caused the victim's death, and that the defendant was the aggressor in provoking the fight or used excessive force, it would be your duty to find the defendant guilty of voluntary manslaughter, even if the state has failed to prove that the defendant did not act in self-defense. Or, if you find from the evidence beyond a reasonable doubt that on or about the alleged date, the defendant intentionally and not in self-defense wounded the victim with a deadly weapon and thereby approximately caused the victim's death, but the state has failed to satisfy you beyond a reasonable doubt that the defendant did not act in the heat of passion or upon adequate, did not act in the heat of passion upon adequate provocation, it would be your duty to return a verdict of guilty of voluntary manslaughter. If you do not so find or have a reasonable doubt as to one or more of these things, it would be your duty to return a verdict of not guilty. And finally, if the state has failed to satisfy you beyond a reasonable doubt that the defendant did not act in self-defense, that the defendant was the aggressor, or the defendant used excessive force, then the defendant's actions would be justified by self-defense, and it would be your duty to return a verdict of not guilty. Proof of motive for a crime is permissible and often valuable, but never essential for conviction. If you are convinced beyond a reasonable doubt that the defendant committed the crime, the presence or absence of motive is immaterial. Motive may be shown by facts surrounding the act if they support a reasonable inference of motive. When thus proved, motive becomes a circumstance to be considered by you. The absence of motive is equally a circumstance to be considered on the side of innocence. The defendant has been charged with larceny of a chose of action, which is the taking and carrying away of another's chosen act as consent, intending at that time to deprive him of its use permanently, the taker knowing she was not entitled to take it. For the purposes of this count, the state alleges the defendant took a cashier's check in the amount of $400. For you to find the defendant guilty of this offense, the state must prove 5 things beyond a reasonable doubt. First, that the defendant took a chose of action belonging to the alleged victim. A chose of action is a banknote, check, or other order for the payment of money issued by or drawn on any bank within this state or within any of the United States. Second, that the defendant carried away the chosen action. Third, that the alleged victim did not consent to the taking and carrying away of the chosen action. Fourth, that at the time of the taking, the defendant intended to deprive the alleged victim of its use permanently. And fifth, that the defendant knew she was not entitled to take the chosen action. If you find from the evidence beyond a reasonable doubt that on or about the alleged date, the defendant took and carried away the alleged victim's chosen action without his consent, knowing that she was not entitled to take it, and intending at that time to deprive the alleged victim of its use permanently, it would be your duty to return a verdict of guilty of larceny of a chosen action. However, if you do not so find or have a reasonable doubt as to one or more of these things, it would be your duty to return a verdict of not guilty. The defendant has been charged with larceny of a chosen action, which is the taking and carrying away of another's chosen action without his consent, intending at that time to deprive him of its use permanently, the taker knowing he was not entitled to take it. For the purposes of this count, the state alleges the defendant took a cashier's check in the amount of $300. Again, for you to find the defendant guilty of this offense, the state must prove 5 things beyond a reasonable doubt. First, that the defendant took a chose of action belonging to the alleged victim. Again, a chosen action is a banknote, check, or other order for payment of money issued by or drawn on any bank within this state or within any of the United States. Second, that the defendant carried away the chosen action. Third, that the alleged victim did not consent to the taking and carrying away of the chosen action. Fourth, that at the time of the taking, the defendant intended to deprive the alleged victim of its use permanently. And fifth, the defendant knew she was not entitled to take the chosen action. If you find from the evidence beyond a reasonable doubt that on or about the alleged date, the defendant took and carried away the alleged victim's chosen action without his consent, knowing that she was not entitled to take it, intending at that time to deprive the alleged victim of its use permanently, it would be your duty to return a verdict of guilty of larceny of a chosen action. However, if you do not so find or have a reasonable doubt as to one or more of these things, it would be your duty to return a verdict of not guilty. Now, members of the jury, you've heard the evidence and the arguments of counsel. If your recollection of the evidence differs from that of the attorneys, you are to rely solely upon your recollection. Your duty is to remember the evidence whether it is called to your attention or not. You should consider all the evidence, the arguments, contentions, and positions urged by the attorneys, and any other contention that arises from the evidence. The law requires the presiding judge to be impartial. You should not infer from anything that I have done or said that the evidence is to be believed or disbelieved, that a fact has been proved, or what your findings ought to be. It is your duty to find the facts and render a verdict reflecting the truth. Now, all 12 of you must agree on your verdict. You cannot reach a verdict by majority vote. When you have reached or agreed upon a unanimous verdict as to each of the charges, your foreperson will so indicate on verdict forms. Now, after reaching the jury room, your first order of business will be to select a foreperson. And you may begin your deliberation when the bailiff delivers the verdict forms to you. Your foreperson should lead your deliberations. When you have unanimously agreed upon a verdict as to each charge and are ready to have them announced, your foreperson should record your verdicts, sign and date the verdict form, and notify the bailiff by knocking on the jury room door. You'll then be returned to the courtroom and your verdict will be announced. Now, members of the jury, you've heard me mention the verdict forms. These are the verdict forms that will be delivered to you shortly after you retire for your deliberations. You'll find they are largely self-explanatory. They have the offenses that I've just defined for you and blanks beside, for example, the first one has a blank beside guilty of first-degree murder or guilty of second-degree murder or guilty of voluntary manslaughter or not guilty. It also has a place for dating and signing by the foreperson. There are 3 verdict forms, one for each of the 3 offenses charged in this case. Also in this envelope will be a notepad and a pen. In the event that during your deliberations you as jurors have any questions or requests of the court, the way you let me know that is by writing that question or request on a slip of paper, summon the bailiff by knocking on the jury room door. Your request or question will be delivered to me. I'll discuss with counsel the best way for us to respond to your request or question, and then we'll probably bring you back out in the courtroom and respond to your request or question. This may be a question or request of any sort, or it could be something about your personal comfort. It could be a matter of you wishing to take a break. Anything at all that you need to inquire of the court about, that's the way that you should do it. Simply write it on a slip of paper and we'll certainly get back to you as quickly as possible on it. Now, as I mentioned, when you retire to your deliberation room, simply select your foreperson and await the delivery of this packet. When this packet is delivered to you, that will be your signal to begin your deliberations, and that will be the point that you may begin to discuss the case among yourselves. Now, we have 2 alternate jurors in this case. We have Mr. Suit or alternate juror number 1 and alternate juror number 2. I want to thank you both very much for your service. It appears that the 12 original jurors in this case are in a position to deliberate upon this case, and so at this time I can excuse you from this matter. I can tell you that you serve an invaluable service for the court by being here available to substitute in should that need arise, and we thank you very much for participating in this case and being attentive throughout. But since we have the original 12, at this time you are excused. Now, the rules I've been reciting to you throughout this trial no longer apply to you with one exception, and that exception is you may not discuss this case with any of the other 12 jurors, the remaining 12 jurors in this case, until they also have been excused at the conclusion of this matter. But the remainder of the rules no longer apply to you, and you're free to go. What I'll ask you to do is make sure that you have all of your personal belongings out of the jury deliberation room. You can follow the bailiff that way. Return your badges to the bailiff. You can leave your notebooks with the bailiff. We'll destroy those for you. Once bailiff, they've cleared the jury deliberation room, if you'll let me know, and we'll then send the jury back to deliberate. Thank you, sir. And thank you again very much. All right. The alternate jurors have cleared the deliberation room, so ladies and gentlemen of the jury, I'll ask you to retire to the jury deliberation room. You may take your notebooks with you. You may take the jury instructions that you've been handed back with you. Select your foreperson, and when you receive this packet, you may begin your deliberations if you'll follow the bailiff in the jury deliberation room. Counsel, outside the presence of the jury, are there any corrections or objections to the jury instructions as they were read to the jury? Frank?
No, Your Honor, not from the
Meyer?
No, Your Honor.
All right, very well. And both of you have had the opportunity to review the verdict forms, is that correct?
Yes,
Yes.
Any objection to those?
not from the state.
All right, very good, thank you. Bailiff, if you'll deliver the verdict packet to the jurors, please. All right, we'll be at ease with respect to this matter. I'll ask counsel to remain nearby in the event that we have a question or a verdict so that we can assemble quickly and not inconvenience the